right on time today. Hopefully the sound is nice and clear for you all out there. This microphone is for show. We're going old school and going straight on the microphone on the phone. We have got Matthew Hague from Frontline Law with us again today. Really appreciate you taking the time to hang out with us again, Matthew, and keep us updated.
Yeah, hi Lucas, thanks for having me.
Awesome. So, yeah, we posted last week, everyone out there, around the case that's being brought against the Crown requesting judicial review for the vaccine mandate that is still in place for home-based carers. So, to give us a bit of background, Matthew, tell us about the case, how it came about, as much info as you'd like to give us.
Sure. So, this case really has its origins back on 6 November 2021. And on that day, the government amended the vaccinations order, which people may be aware is the legislation that imposes the vaccine mandate at that time on various professions, corrections, health workers, border workers, etc.
Yeah.
Now it only relates to care workers. So on 6 November, the government removed an exemption effectively that used to apply to home-based care and support workers. So these people are typically family members who care for their loved ones, whether that's parents or grandparents or other family members. And they previously had an exemption because it was just common sense. I mean, these are people who usually live with the people they're caring for. And so they're going to be exposed to them no matter what. It makes no difference whether they're vaccinated in terms of risk.
Yeah.
For some reason, and we don't know why, on 6 November, the government decided to amend the vaccine order to remove that exemption. And what the effect it had was these people are still having to care for their loved ones, but they're not getting the financial support that they were getting up until that date. Right. And this is really important support for these people. It's had a big impact. So that's the background. And so on 1 September, actually prior to that, we wrote to the government and we said, look, this doesn't seem right. It doesn't make sense. This was about 7 weeks ago that we sent this letter. Can you please review it and look at removing the vaccine mandate from home-based care and support workers? And perhaps unsurprisingly, but still a little bit disappointing, we had no response whatsoever from the government, nothing.
Right.
And so unfortunately, the care and support workers that we represent have no choice but to go to the High Court and file for judicial review against the vaccine order.
Yeah, okay. So, I mean, have you done, in your role as a lawyer for Frontline Law, when you do such a thing as contact the Crown about anything, have you done that in the past, and do you usually get a response within a usual time frame?
I mean, not a quick response, but, you know, obviously the government have a lot of things to do, but often we do get some kind of response. And it was disappointing that there was just no response, not whatsoever, not even an acknowledgement of the concerns that this group had, not any attempt to explain why the mandate was justified. And these are real people, and it's had a real impact on them. And I was sad to see the government not even take the time to respond to them.
Yeah, 100%. It does sound a little bit sad, but also not surprising, I would probably say, and a lot of followers out there would probably agree, given the events of the last couple of years. So, hey, look, what's the big question that's come out from a lot of comments on when we initially posted the press release was a lot of fans of Ashley the Advocate. She's a social media personality as much as she's doing really great legal advocacy work. And she obviously had a couple or one or two cases that were for home-based carers as well. And people were wondering why there was a double up. So are you able to explain the difference for us there between what the great work she's been doing and this case here?
Absolutely. And so, look, I'll start by saying it's great work. It was a great result that Ashley had in the employment court. Yes. And this is a decision that was released in July this year, and so a few months ago. And it's a really good question. What is different about these legal proceedings, and why is there any point in bringing them if Ashley's already been successful? And there's a few good answers to that, which I've got.
Cool.
So the first one is that let's call it the CSN case, because that was the acronym given to the applicant. That was brought by an individual against their employer, which was the Royal District Nursing Service. It wasn't the government. And so the decision was binding on those parties. It's not binding on other employers. And so while the employment court decision does have precedent value, and that if other employees decided to bring a legal action as well, they could rely on it, they would still need to bring that separate legal action individually. There's reasons why that might not be possible, or it might be difficult. And a big one is that you only have 90 days to raise a personal grievance before you can bring a legal action in the employment court or employment relations authority. And for a lot of people, that time frame is going to have expired. And so even if they want to rely on Ashley's decision, they're not going to be able to.
Got you. Okay.
And there's a couple of other reasons too. One being that the case was against an individual employer. We see a big problem being the government. They're the one who made the vaccination order. They're the one who on 6th November last year decided to apply it to home-based care workers, and they're the ones who should be scrutinised by the High Court. So the value that we see in these proceedings, if we're successful, is that it's a rebuke from the courts against the government's unjustified actions that will have wider consequences and that potentially could result in back pay for a much wider range of people than if people are going to have to bring their own individual actions.
Yeah, sure. That makes perfect sense. And we've had comments, and I've actually had direct messages as well asking that question. So that's good clarification around that. So do you have some sort of a timeline? I mean, I'm sure we got such a big response when we put the press release up there. People are really interested to hear what's going on here. Like I say, people that are in that same position, as well as just people that obviously are anti the mandate side of things. So what sort of timeline have you got, or could you give us around when we potentially might hear some more about what's going on?
Yeah, so look, we've only filed on 1 September. Realistically, it's going to probably be about 6 months, give or take, before we actually get the hearing in front of the High Court. So that's the sort of time frame we're working to.
Okay, cool. Yeah. Excellent. All right. And what sort of confidence do you have around, obviously we keep referring back to Ashley's work, and, that's an individual employment law side of things, but does that give you confidence, or otherwise what confidence might you have?
No, it does. I think what Ashley's case says to me is that the courts recognise that this is a pretty silly situation where you've got people who live with the people they care for. The only difference the vaccine mandate has is that they're not getting the financial support they need. They're still having the same level of contact. And in fact, I think there's actually a greater risk because some of these people are having to bring in paid external caregivers, which although they're vaccinated, as we know, vaccination does not stop the spread and transmission of COVID. So there's actually an increased risk posed with the vaccine mandate.
Yes.
So what level of confidence do I have? A high level of confidence. I think this is one of the most egregious examples of a vaccine mandate, which the courts have said again and again, do limit our fundamental rights. The question is whether that limitation is justified. And in this case, for the reasons I've given, I just think it's completely unjustified.
Yeah, 100%. We may have, and we've brought this up a number of times over the last couple of years, there may be, it's still a tough conversation, but there may be a better conversation to have. Should it be 100% effective in stopping transmission, you might be able to have a conversation. But as you say, we know that that's not the case. So, hey, look, that's probably all we need for now, Matthew. Really, as I say, really appreciate you giving me a call the other day and organising this time to catch up and inform our viewers. We will watch this with pretty closely, and let's keep in touch. And when we've got further and like I said, potentially 6 months or more time, let's touch base again and see what we can update people with.
Yeah, thanks, Lucas. Look, I really appreciate the support from you and your viewers, and I know that the applicants really support it as well. And I also know that there's a wide range of people who have been affected by these things. So I acknowledge the harm that it's done to all those people, and I thank them for their support.
Awesome. And we did see your little brief appearance in the River of Freedom documentary trailer. So it's good to see you on there, continuing to speak the truth. We really appreciate what you and Frontline Law has done for New Zealand citizens in the recent past. So, thanks again, and we'll talk to you again real soon.
Thanks, Lucas. All the best. Bye.
Awesome. See you later.